care providers fear that they would be prosecuted or in some way penalized for helping her through her miscarriage, and only helped her when she got to the point where she had sepsis, a life-threatening situation. I have met with and talked with doctors who are in fear of losing their license, of being prosecuted, and of this situation actually having an impact on the relationships of trust that they have with their patients. This indeed is a healthcare crisis in America, and we have to acknowledge and understand it to be just that. And then 5 days ago, a district court in the state of Texas ruled to block access to abortion medication in every state in the country. In effect, if this ruling stands, creating what could very righteously be considered a nationwide ban, at least as it relates to what we believe to be half of the women who, when seeking abortion care, receive it through abortion medication. So we have, in effect, a situation where politicians and politics have driven lawyers to go to a court of law where a judge, who is not a medical professional, is making a decision to undo the ruling over 20 years ago of the FDA that declared a specific medication safe and effective for the American people. So one must appreciate that when we think about the integrity of our healthcare delivery systems and attacking the very credibility of the FDA on this one matter for the sake of politics and a political agenda, the wide sweeping ramifications this can have. And I'd ask every person who is aware of this to understand the implications of this ruling by just opening your medicine cabinet. Because it is very likely that you rely on some type of medication prescribed by a doctor approved by the FDA to alleviate your health concerns and to improve your condition in life. So the ramifications of this decision 5 days ago are wide sweeping, and for that reason require, we do believe, a very serious response. And again, I will state that our administration and our President, Joe Biden, has been very clear that we will stand to protect the integrity of the healthcare system in America, and we will stand to protect those who have a right to be able to make decisions about their own body and their own life. Also on this issue is the real risk of damage to and attacks on patient privacy. So let's think about that. 26 years ago, in 1996, our country agreed that we needed this thing called HIPAA, because we all agreed that when it comes to our medical records, there are just certain things that should be private. If you choose to share it, you can, but it's your private business. It's the business between you and your healthcare provider, and nobody else's business. So we passed HIPAA to say that medical records would be private. There was an exception in HIPAA that said that if law enforcement needs it in pursuit of a criminal matter, an investigation, if they had a court order, they may have access to those records. Well, what's the connection between that and where we are now? Since the Dobbs decision in particular, many states have proposed and passed laws that are now going to criminalize healthcare providers for providing reproductive health care. It's going to be a crime, which means that it is very likely if law enforcement requests your personal and private medical records, they may be entitled to receive them. So part of the conversation that we are having today is what we can do, and Secretary Becerra will talk about that in particular, to reinforce protections for patients' privacy as it relates to their records and their communications with their physician. So again, I will say our administration is fighting on every front to do what we can and what we must to protect the American people and the integrity of the healthcare system in our country. And with that, I'm going to now pass the mic, as it were, to our Attorney General, Merrick Garland, to give us an update on litigation and the actions that the Department of Justice has taken in this regard.
Thank you, Vice President Harris, for bringing us together today. The fallout from the Supreme Court's decision last summer to overturn Roe v. Wade has been swift and severe. Since then, the Department of Justice has worked with commitment and urgency to defend the reproductive freedoms that are protected by federal law. During our last meeting, I discussed the work of the Department's Reproductive Rights Task Force to safeguard federal protections of reproductive rights. Today, and following President Biden's memorandum on further efforts to protect access to reproductive health care services, I want to provide another update on three important areas of our work. First, we continue to advise federal agencies on legal issues relating to reproductive health in the aftermath of Dobbs. And we are defending agencies as litigation arises. More than 2 decades ago, the Food and Drug Administration approved the drug mifepristone as safe and effective to terminate early pregnancies. But a decision issued last Friday by the District Court for the Northern District of Texas would displace the FDA's expert judgment and roll back the agency's approval of mifepristone. Justice Department strongly disagrees with the court's unprecedented decision to do that in Alliance for Hippocratic Medicine versus FDA. We therefore appealed the decision, and we filed a motion for a stay pending that appeal. As our filings make clear, the decision would severely harm women across the country. It would deprive patients of a safe and effective medication to manage their reproductive health, and it would allow doctors to challenge FDA approval of any drug or any other federal action that allegedly injured third parties. This could happen to any medication that Americans rely on, no matter how essential it is and no matter how long ago it was approved. The Justice Department will continue to defend the FDA's approval of mifepristone, as well as the FDA's role as the expert body that Congress has designated to make decisions about the safety and efficacy of prescription medicines in this country. Second, we are continuing to vigilantly monitor state laws and enforcement actions that threaten to impinge on federal protections of reproductive rights. For example, we are continuing to litigate our challenge to Idaho's abortion ban to the extent that it conflicts with the Emergency Medical Treatment and Labor Act, known as EMTALA. As we explained in our filings in that case, Idaho's law prohibits abortion when it is the medically necessary treatment to stabilize a patient's emergency medical condition. Last August, the District Court for the District of Idaho granted our motion for a preliminary injunction blocking enforcement of Idaho's law as applied to medical care that is required by EMTALA. In addition, as I said on the day that Dobbs was announced, women who reside in states that have banned access to comprehensive reproductive care must remain free to travel to states in which that care is lawful. And under the First Amendment, individuals must remain free to inform and counsel each other about the reproductive care that is available in other states. Justice Department will defend these bedrock constitutional protections, and we will continue to evaluate private party litigation that would benefit from our participation. Third, we are continuing to work to protect healthcare providers and individuals seeking reproductive health services. In this regard, we are enforcing the Freedom of Access to Clinics Act, known as the FACE Act. That law prohibits anyone from obstructing access to reproductive health services, including abortion services, pharmacies that provide reproductive health services, and pregnancy counseling services, through violence, threats of violence, or property damage. We are working to ensure that federal prosecutors across the country are equipped to bring FACE Act cases. But in addition, we are conducting training for U.S. attorneys' offices on the FACE Act. Our National Task Force on Violence Against Reproductive Health Care has prepared a training webinar for state attorney generals' offices. And we have emphasized that Civil Rights Division attorneys in the Justice Department are always available for consultation and technical assistance. I'm grateful to Associate Attorney General Vanita Gupta, who is leading these very important efforts for the department, and I'm grateful to all the professionals across the department who are working to ensure America's freedom to reproductive rights protected by federal law. Together and with the people in this room, we will continue to fulfill the Justice Department's founding responsibility to protect the civil rights of all Americans. Thank you.
Thank you. Thank you all.
Actually,
And then we're
let's
gonna now
talk to,
have
turn to
Secretary
Secretary
Becerra
first.
Yes, that's right.
Actually, let me begin by thanking the Attorney General for acting so swiftly to protect reproductive rights. And Madam Vice President, thank you for your longstanding work to champion the healthcare rights and the privacy of Americans throughout the country, and certainly women when it comes to reproductive rights. And to Jennifer Klein, the co-chair of this task force, thank you for the work that your team has been doing overall. We are trying to do everything we can at the Department of Health and Human Services to continue to protect those rights, the access that Americans have grown accustomed to having, on top of working with the Attorney General on this case that we have before us on the mifepristone medication. We're also now taking action. Today we announced that we will be issuing a proposed rule that will try to protect those privacy rights that the Vice President spoke about. We want to make sure that people can continue to access the doctor, the health care they need, and know that when they do so, that the information that is collected remains private in the hands of that individual and the caregiver that provided the information. We believe that this rule will assure that doctors, other healthcare providers, and health plans will not be disclosing individuals' protected health information, including information related to reproductive health care under certain circumstances. By safeguarding this sensitive information related to reproductive health care, the rule will bolster trust between that individual as a patient, their healthcare providers and healthcare plans, and enable those individuals to obtain high quality, accurate, and appropriate healthcare information, and help healthcare providers when it comes to giving complete and accurate information to their patients. We want to take a minute at HHS to acknowledge the people that make that possible in our department as well. And here I have to thank Director Melanie Fontes-Rayner, who is the director of our Office for Civil Rights. She is the one that is working with the Department of Justice, with White House and others from HHS to make sure we continue to be a good partner in this effort to protect a woman's rights. Her team, Director Fontes-Rayner's team, has been conducting listening sessions throughout the country. We've heard firsthand from women how their healthcare providers are being targeted by hostile actors, how there are people who are trying to weaponize this private information that's protected, they're trying to punish those who seek legal reproductive health care. And I think it's important once again to emphasize, these are people who are being attacked for trying to access health care that is legally presented to them and legally available to them. This rule will strengthen privacy protections for patients and providers, and we hope that what we can do is send a clear message that we will continue to make sure that people are afforded their rights. I also want to mention that the Department of Health and Human Services will be issuing guidance to help protect patients' electronic health information, including their information related to reproductive health care. The guidance will make clear that patients have the right to ask their electronic health information generally not be disclosed by their physician, hospital, or other healthcare provider, including to other healthcare providers. The guidance also reminds healthcare providers that HIPAA's privacy protections continue to apply to patients' electronic health information. And finally, Madam Vice President, HHS is announcing that it will issue a new notice of funding opportunity to establish a safe and secure national hotline to provide referral services for women in need of accurate information about their legal reproductive health care options. The hotline will provide information to patients served by the Title X Family Planning Program who request information related to prenatal care and delivery, infant care, foster care or adoption, or pregnancy termination. Without these steps, individuals may be hesitant to interact with providers or health plans or pharmacies or certain digital health applications out of fear that their data will be tracked and or shared with the state agencies, law enforcement officials, or others. And so we want to make sure we do everything we can to ensure patient privacy, bolster trust between individuals and their healthcare providers, and enable individuals to obtain high quality, appropriate health care. So, Madam Vice President, I think you see that this is a team effort to try to protect the rights of all Americans when it comes to their health care. Thank you.
Thank you, Secretary Becerra.
Great, now we're going to transition to the closed press portion of our meeting.
Thank you, Paul. We're moving out. Thank you, Paul. Thanks, everyone. Thanks, everyone.
Thank you, guys. We're going to move.